This is Dr. David Shine, and welcome to Business Law 101. One of the interesting cases that starts with Chapter 15 is the Notre Dame lawsuit, where a student claimed that he couldn't be thrown out of school shortly before he graduated. And the argument was Promissory Estoppel. And he claimed that Notre Dame had entered into an implied contract or an equitable contract that said he wouldn't be thrown out. Now, of course, universities have significant policies and procedures if a student engages in illegal conduct, if a student assaults a member of the public or fellow student, if a student is caught in a significant cheating incident, they can be put out of the school and without refund of tuition. So these are pretty well established cases, but again, that is at the beginning of Chapter 15. Now, promissory estoppel is kind of a funny word. Again, we want you to keep in mind the way it's constructed. Estoppel, it sounds like it is estopped, to be prevented from arguing against the promise that the other side claims that you made. So here's some concepts. And again, this is a slide with an important definition like this. You may want to keep track of this slide, slide 24. So there's a definite promise. And the parties should have expected that the promisee would rely on the promise. A reasonable person would have accepted it. And the promisee relied on the promise and had a substantial detriment. Let me remind you of a case of an example I mentioned to you. You have a representative of a big company, like a Shell Oil, a Mobil, ExxonMobil, somebody like that. They come to your machine shop and they say, hey, we desperately need some parts to be manufactured. We're working on getting the contract in place right now, but what we want you to do is get ready so that when we call you next week and say we've got purchasing authority, you're ready to rock and roll and make this for us. Based on that, your machine shop goes out and buys 40 blanks, ready to go, ready to make this, maybe book some people for some overtime for the subsequent week. And bad news, Monday or Tuesday of the next week comes and goes, no contract, and your contracting officer from the big company calls up and says, hey, guess what? We didn't get approval to have you manufacture the item. Now you're sitting there like an idiot with 40 blanks ready to do work, and there's no work to be done. In those cases, that is classic promissory estoppel. You can say, our machine shop acted reasonably, and at a minimum, the big company should be required to buy those blanks that we bought in reliance on the verbal representations that we needed to be ready quickly to do the job. So that's a classic example of a possible promissory estoppel situation. This is Dr. David D. Shine for Business Law 101. If you've enjoyed this episode, please subscribe on your favorite platform.